કે કારણ કે આમાં આપણે કોઈ પાર્ટિસિપન્ટને નહીં જોઈ શકીએ. हेलो, हाँ प्रशांत,
मैंने किया है सर सेशन, अभी स्टार्ट कर सकता हूँ.
रुकना. स्ट्रीमिंग अभी मुझे बोल, मैं सिर्फ पेपर खोल के बैठ जाऊँ?
खुला है ना सर? हाँ, आप पीडीएफ वो खोल लो, ये हटा दो.
ये हटा दो ना, तो मुझे सिर्फ कैमरा में देखना है, राइट? डन. तो मैं सिर्फ कैमरा में देख के, किधर गया मेरा पेपर?
इसमें खुला है.
नया वाला पेपर है ना?
हाँ, ये अभी जो मेरे को भेजा है सर.
डन. शैल वी स्टार्ट द स्ट्रीमिंग?
यस सर.
कितने पार्टिसिपेंट्स अभी वेट लिस्ट में, ऐसा कुछ है वहाँ पे पता चल रहा है?
मैं चेक कर लेता हूँ.
कर पहले. हेलो, हेलो. हाँ सर, खबर છે. हाँ, बट यू नॉट स्टार्टेड स्ट्रीमिंग. Sir, because we both are connected via OBS.
No, we are not. मैं normal login करो सर.
Okay. All right, good evening, friends. Wish you all a very, very good evening on behalf of entire team PDLC. Guys, we are here today, just about 4 days before your CA Foundation exam with a very unique concept, and that is a AI-based paper. A AI-based paper of CA Foundation law, which we at PDLC thought should be discussed with all the students. If you look at the recent final CA AFM paper, Advanced Financial Management, that paper was purely based out of AI. And the students at final CA had a lot of important prompts given. Right? So that is something which we will be doing right now. Let us get into the discussion. I hope all of you can see the paper. So it's a similar kind of a paper, 3 hours, 100 marks. The paper is paper number 2, business law, general instructions, which you will find over here. Answer all questions, working note should be forming part of answers and all of that. Everything is drafted as per AI. This paper is intentionally drafted at a difficulty level higher than standard ICAI examination pattern. Look at this, the last point which we wanted to highlight, right? So let's look at it. Question 1 will be compulsory. So guys, like as usual, me and Nihal sir, we will be dividing the paper into two parts. The contract and the SOGA part will be taken over by Nihal sir, and initially I will be talking about all the other than contract and other than SOGA questions. So let us start with question number 1. So if you look at question 1, okay, so it happens to be question 1A, a question based purely on Contract Act. So that will be taken over by Nihal sir. I'll be going on further. Question number 1B. All right, let's have a look at that. Come on. So 1B, first question. The Articles of Association of Delta Private Limited provided that any borrowing above 50 lakh rupees required approval of the Board of Directors through a resolution. That is something which is written in my internal association. That is Articles of Association. The finance manager of the company borrowed 2 crores from a nationalized bank without obtaining such approval. The bank acted in a good faith and had no knowledge of the internal irregularity. If you read the question until now, by now most of you would have understood that this question is a question based on a particular doctrine. They have very simply given internal irregularity and all of that. So what we are here talking about is the doctrine of indoor management. The doctrine of indoor management. The question's last line says, discuss whether the company is liable to repay the loan. So we all know that as per the doctrine of indoor management, section number 399 of the Companies Act 2013 says that once a company gets incorporated, MOA as well as AOA are publicly available documents, and any outsider entering into a contract with the company shall have thorough knowledge of only the MOA. As per indoor management, outsider can safely assume that the internal rules, internal compliances would have been complied with, and therefore, as per the doctrine of indoor management, the outsider remains protected. Don't forget that we have a very important judgment over here to write about the Royal British Bank versus Turquoise. And as per that particular judgment, beta, here the nationalized bank will not suffer any damages. And as per the doctrine of indoor management, the entire money will become payable, but the board of directors will become liable for the balance amount. So that is something which you need to keep in mind when you're talking about the doctrine of indoor management. That's your 4-mark question where you talk about the judgment also, Royal British Bank versus Turquoise. So question number 1B, the first part, 4 marks, is a simple question based on the doctrine of indoor management. Now let's look at 1B, second part. The second part, it's a very simple question. The entire 7 marks is based on indoor management. The next one is a theoretical question. It says, state any 3. I mean, it should not be any 3. They are all the 3. The 3 exceptions to the doctrine of indoor management. 3 marks, 3 exception. First, if you have actual or constructive knowledge of the irregularity, we also do one judgment over there, Howard versus Patent Ivory Manufacturing Company. That is a very important judgment. Second is suspicion of irregularity. There also we do one judgment, Anand Bihari Lal versus Dinshaw and Company. That's again an important one. And third is forgery. A simple, straightforward theory question which is based out of indoor management exception. So question number 1B completed, 4 marks on indoor management and 3 marks on exceptions to indoor management, right? That's our 7 marks. Going further, okay, so this again is a question which will be picked up by Nihal sir later on. Let's go on a little further. Question number 1C to be picked up by Nihal sir. Next, question number 2. Okay, again, coercion, undue influence. Nihal sir will pick it up. All right. Question number 2B is what we will be looking at now. Let's have a look at this. Question number 2B. First point. A, B and C were partners in a textile firm. Without knowledge of the other partners, A borrowed 25 lakhs in the firm's name for speculative crypto trading. Interesting. The transaction resulted into losses and the lender demanded the payment from the firm. Examine whether the firm is liable. See, first of all, here we will be talking about liability of the firm. That's as per section number 27 of the Partnership Act 1932. So if you look at the liability of the firm, if the partner was authorized to borrow the loan in the name of the firm, then in that particular case, although he borrowed the firm without the knowledge of the other partners and used that for crypto trading, that is something wrong. But the firm becomes liable to the third party. However, the firm will not bear this liability out of its own pocket. They will make the partner A personally liable. They will make partner A personally liable. So it's a very small question, a 3 marker from the Partnership Act 1932. We are talking about liability of the firm, right? That is in the sequence of section number 25, 26 and 27. All right. Going on a little further, question 2B, the second part. Ravi, a minor, was admitted to the benefits of partnership. Wait, we are looking at section number 30. We are looking at section number 30, minor admitted for the benefits. As a beneficiary, on attaining majority, he was unsure whether he wanted to continue to be a partner. Okay, he seeks for advice with respect to the legal provision applicable. So guys, this is something which we have done in the class. So once you attain majority, you have a period of technically 6 months. Once a minor was admitted as a beneficiary, attains majority, he gets a period of 6 months after his 18th birthday. Within that period, he will have to make a choice. Number 1, either he elects to become a partner of the firm, or B, he elects not to become the partner of the firm or not to continue being a partner of the firm. First option. As per section 30, if the partner elects to continue being a partner of the firm, first thing, please make sure the time limit. Time limit is 6 months from his 18th birthday or the date on which he actually got to know that he was admitted as a beneficiary, whichever date is later. So let's assume 6 months from 18th birthday, he should first give a public notice. And once he continues, now comes the important point. If he continues to be a partner, he shall become liable for everything that happened in the firm from the day when he was appointed as the beneficiary of the firm. That is an important point. But if after his 18th birthday he decides not to continue to act as the partner of the firm, then from that date on which he gives the notice, he will no longer be liable. But remember, after his 18th birthday, up to the date on which he gives the notice, he continues to remain liable. As a partner of the firm. 3 marks, very easy. Again, it's a question on section number 30, something which you have done in the class. So question number 2B, first and the second part, fully done. Partnership. All right, going further. P purchase the water purifier. Okay, Nihal sir will do that. Again, Nihal sir will do that. Okay, next is a question on agency. Again, it will be done by Nihal sir. We are into question number 3A. All right. 3B. Lovely. Let's have a look at this. Question number 3B. A question on Companies Act. Have a look at it. Bright Vision Private Limited. 3B, first question. Bright Vision Private Limited has 210 members. 15 are ex-employees holding shares allotted during employment. So guys, come on. Private company, section number 2 clause 68. Don't forget that whenever in a private company, ESOPs are issued, whether you are my existing employee, whether you are my former employee, for the purpose of counting 200 members, I will not include you in the total number of members. So although I have 210, 15 ex-employees not to be counted. Okay, sir. 8 are joint holders. Wait, one more point. For a private as well as a public company, joint shareholders shall always be counted as one. Shall always be counted as one member, one share, one vote. So 8 will be counted as 4. So I'll have to deduct 4 from here. I'll have to deduct 15 of ex-employees, and next one, 12 are present employees holding shares. Holding shares. Alright, so we are assuming over here that those present employees are also allotted shares as a ESOP. So while I count my total, I will have to first deduct 15, then deduct 4, then deduct 12. So if I look at the total number of deductions, my deductions are going to be 15 plus 4, 19, 19 plus 12, 31. 31. So if I deduct 31 from 210 members, I have 179 members left, which means, am I fulfilling the requirement of total number of members for the purpose of a private company? And the answer is yes. Therefore, the company fulfills the requirement. Excellent question. 4 marks. If people can remember, there is a similar excellent question in the question answers that you've done. Jagannath Oils. It's a superb question, beta, based on the total number of members of a private company. Right? Going further, question number 3B1 done. 3B2. Explain the doctrine of constructive notice and its effect on outsiders dealing with the company. Wow, lovely. What is the doctrine of constructive notice? Come on, pure theory. As per section number 399 of the Companies Act 2013, any outsider dealing with the company shall have a thorough knowledge of both MOA as well as AOA of the company. And if the company forgets to fulfill or company violates the fulfillment of its own MOA or of its own AOA, and that is not told to the company by the outsider, then the outsider shall be liable. Don't forget 2 statements. Doctrine of constructive notice is a dark cloud for the outsider, and the doctrine of constructive notice is made to protect the company against the outsider. Is that clear? It's that clear. That's a simple question. Question number 3B, second part. Right? Going further. Oh, 3C. What do we have here? Very simple. LLP. LLP. Come on. Let's have a look at that. Explain the essential features of a limited liability partnership. Come on, guys. We have had a lot of answers on this. Very simple. First, limited liability. We have lots. Perpetual succession, common seal, but please remember common seal is no longer compulsory. You will have signature made by digital signature certificate. Then we have what? Then you have an artificial legal person, separate legal entity. Yes, then we can have conversion into LLP, a very important concept. So whether you are a partnership firm or a private company or an unlisted public company, you can get converted into a LLP. Don't forget, merger of one LLP with another LLP. And a very important point of LLP's feature is a designated partner. A designated partner. And one last point is flexibility in the management. Flexibility in the management. Also, you can talk about two more things. Compulsory incorporation. You can also talk about the number of partners. Minimum 2, maximum unlimited. Correct? That is essential features of a LLB. Very simple. 4 marks. You can write about 7, 8. Nothing more. Then very simple again. 3 marks. Distinguish between LLP and a partnership firm. We have discussed this. Simple point. In a partnership firm is governed by the Partnership Act 1932. LLP is governed by LLP Act 2008. Here you will have no separate legal entity. Partnership firm is not considered to be a person in the eyes of the law, but a LLP enjoys a separate legal entity. Partners' liability in a firm is unlimited. Partners' liability in a LLP is limited. In a firm, you have mutual agency. Every partner is a principal of himself, but is also an agent of the other partner as well as the firm. But in a LLP, every partner is an agent only of the LLP, of no other partner. In a firm, 2 to 50 partners. In a LLP, 2 to unlimited. There can be multiple type of partners: active partner, sleeping partner, dormant partner, but only partner and a designated partner. That's it. 3 marks. Don't write much. Don't get carried away. Right? Going further. Question 4 seems to be quite interesting. It is from Negotiable Instruments Act. Let's read that. 7 marks. A check was issued by X to Y towards repayment of a legally enforceable debt. A legally enforceable debt, meaning it's a contractual payment. Presumption of a contractual liability. The check was dishonored due to insufficiency of funds. Wow. We have 3 reasons for dishonor of a check to be an offense: insufficiency of funds, stop payment, and closure of the bank account. Lovely. Discuss all the legal requirements for initiating prosecution under 138 of the Negotiable Instruments Act. Discuss whether prosecution can be initiated if the check was issued as a gift or donation. Lovely. Let's have a look at this. Guys, we know for any dishonor of a check to be an offense, 3 things. There has to be insufficiency of funds, or stop payment, or closure of the bank account. And very important, payment has to be contractual in nature. Payment has to be contractual in nature. Now there are steps. First, the check should have been deposited within 3 months. Within 3 months. Once you deposit the check and the check gets dishonored, the dishonor should be intimated to the drawer within 30 days. Within 30 days. Once the dishonor is intimated, the drawer will be given a fresh period of 15 days to make a new payment. If 15 days are over and a new payment is not made, then what? Then we give you 1 month to file a suit against the drawer in the court of law. And once the suit is filed, drawer could be made liable for imprisonment up to 2 years or twice the amount of check as penalty, or like we say in the class, if you're lucky, both. Is that correct? Correct. But don't forget, there is one more part in the answer. If the check was given as a gift or as a donation, then guys, this cannot be an offense, because there is a presumption of contractual liability. That's it. 7 marks. You have to write entirely whatever we have discussed right now. Okay, looks easy. Fine. Let's go a little ahead. Question number 4B. Nope. That will be taken over by Nihal sir. Question 4C. What do we have? It is a question on your favorite Indian regulatory framework. Again guys, if you see 6 marks coverage, it's a very easy question. Explain the meaning of law. Law is the set of rules and regulations imposed by the government for maintaining law and order and justice. So that is one paragraph which you will have to write. Sources of law. Again 4 sources of law. Constitution of India, the parliamentary laws, laws made by the Supreme Court, and then you have customs and traditions. So for 3 marks, both of them, you can easily write that pure theory question. Pure theory question. Right. Let's have a look at next one. This was question number 4C. Right. Going further. All right. Question number 5. Question number 5A is what we are looking at. Apex Green Energy Limited is a public company incorporated under Companies Act 2013. The Memorandum of Association of AGEL states that its main objectives are manufacture and sale of solar panels, renewable energy projects, and allied infrastructure activity. Allied infrastructure activity. Articles authorize board to borrow up to 200 crores. Borrowing beyond this limit requires approval of shareholders by a special resolution. In June 2025, the board of directors of AGEL decided to invest 40 crores in an online betting and gaming startup, claiming that diversification would increase profits. For this purpose, AGEL borrowed 60 crores from Eastern Commercial Bank Limited. At the time of borrowing, AGEL had already borrowed 170 crores. ECB verified only the articles but did not examine the memorandum. The CFO knowingly concealed the object clause from the bank. Out of the borrowed funds, 40 crores were invested in the gaming startup, gone. 10 crores were used to repay existing lawful loan, excellent point. And 10 crores were used for purchase of machinery for the solar business. Again, okay. The gaming startup later collapsed, causing heavy losses. Minority shareholders filed a suit alleging that the investment was ultra-virus. Borrowing was invalid and the directors should be made personally liable. One independent director had recorded dissent in the board meeting minutes. Excellent question on the doctrine of ultra-virus. Now guys, gaming startup may invest karna. Okay, that was not our object. Just look at the object clause. Manufacture and sale of solar panels, renewable energy, and allied infrastructure activity. Nowhere allied infrastructure activity will include gaming. I hope you understand that. So online betting, gaming, not allowed. Is that ultra-virus? Yes. That is ultra-virus. Right? Now, articles authorize how much to borrow? 200 crores. 200 crores were to be borrowed. But borrowing beyond that would require a SR of the members, special resolution. Board decided to invest 40 crores. For that, some borrowings were done. Check it out. AGEL had already borrowed 170. 170. Now, the CFO knowingly concealed the object clause. Out of the borrowed funds, 40 crores were invested in gaming. Tell me, are they ultra-virus? Yes. 40 crores invested in gaming are completely ultra-virus, beyond their powers. Wait sir, 10 crores repay of existing loan, valid. That is valid. That's not ultra-virus. That's not beyond your power. 10 crores were used for purchase of machinery, valid. Not ultra-virus. But 40 crores for gaming startup, surely ultra-virus. You'll have to write that as per the doctrine of ultra-virus, anything done beyond the powers will be considered as void, and the person committing that shall become personally liable. Members of the company have no rights to ratify any ultra-virus transaction which is ultra-virus the MOA. However, members do have the power to regularize that for the future, not the existing transaction. 40 crores existing transaction cannot be ratified. If it was ultra-virus the AOA, it can be ratified. Ultra-virus the MOA cannot be ratified. But something which you want to allow for future can be regularized by altering the memorandum of association. Is that very clear? So the investment was ultra-virus. Directors will become personally liable to the tune of 40 crores which they invested in the online betting and gaming startup. Is that clear? And if there are some directors who have not been a party to this, then they will not be liable. Then they will not be liable. Is that clear? Alright. That is my question number 5A. Okay, good question. Let's look at 5B. Come on, 5B1. A signed and delivered a blank stamped promissory note to B, authorizing him to fill only 40,000. Only 40,000. B fraudulently filled 1,20,000 and transferred the note to C, who became the holder in due course. Who became the holder in due course. Determine the liability of A. Guys. If you are the holder in due course, you have the right to recover the money up to the extent of the stamp value. Up to the extent of the stamp value. So does the holder in due course get the right to recover the entire money? Yes. But whenever there is a forgery done, whenever there is a fraud done, it makes the entire instrument as a nullity. So in this case, holder in due course has the right to recover the money, but unfortunately A will not have the liability to pay because the forgery will make the instrument as a nullity. Please remember this, right? It's a very good question, beta, but very easy. Okay, 5B2. Define a check and discuss its parties. Oh, lovely question. 3 marks. Guys, what is a check? Come on. 3 parts. Check is a bill of exchange drawn on a specified banker and not expressed to be paid otherwise than on demand. Check is the bill of exchange drawn on a specified banker, not expressed to be paid otherwise than on demand. That's the definition of a check. And what are the parties? 3 parties. Drawer, drawing bank, payee. Drawer, drawing bank, payee. Simple. Alright. Going further. Question number 5B done. 5C. Again, a firm. A firm was dissolved on 1st April. No public notice of dissolution was issued. That's a problem. Subsequently, one of the partners purchased goods in the firm's name from a supplier who had no knowledge of the dissolution. Can the supplier recover from all the partners? Guys, unless a public notice is served, all the partners continue to remain jointly and severally liable. So, in case of a dissolution, the firm has to give a public notice. Once a public notice is given, partners remain liable only for 1. All the acts of winding up, and 2nd, for all the incomplete businesses. But if the public notice is not given and the dissolution has started, the partners continue to remain liable in a joint and several capacity. So the partners will become liable. Clear. Going further, can a partner transfer his share to a third person and confer management rights? Oh, wait. Transferee of rights. So this is as per section number 29. Section number 29 of the Indian Partnership Act 1932. So if I transfer a part of my rights to the transferee, please remember that transferee will not be a partner of the firm, will not have his name as per the partnership deed, will not get a say in the decision making, and therefore cannot be given any management rights. Don't forget, this person will be as good as a sub-partner. Is that clear? Question number 5C2. The second part. Done. 5 questions done. Guys, even if it's an AI paper, I believe it is good enough. We have done almost everything that has been asked. Okay, did I say too much too soon? Let's have a look at question number 6. Come on. Question 6A is that on companies. Oh no, that's partnership. Lovely. Let's have a look at that. Silverline Consultants is a partnership firm consisting of partners Aman, Bharat, and Chetan. Partnership deed provides that no partner shall borrow more than 10 lakhs in the firm's name without consent of all partners. And no partner shall engage in the competing business, obviously. Aman, first partner, without informing other partners, borrowed 60 lakhs from Prime Finance Limited in the firm's name. Gone. You have taken 60 lakh rupees. Okay, and you should have taken approval of all the partners. Okay, out of this amount, now something interesting. 25 lakhs were used to discharge firm's liability. Okay, although you have borrowed 60 lakh rupees without the consent, 25 lakh rupees were used for lawful discharge of firm's liability. So to that extent, we can forgive you because you have used that money for lawful discharge of firm's liability. 20 lakhs were used by Aman for personal crypto. What is wrong with AI? Two times in the same paper, crypto came into picture. Okay, fine. So 20 lakhs used for personal crypto trading. Balance was lost in speculative transaction. AI feels everyone is doing only speculation. Alright, fine. So guys, 60 lakh rupees borrowed for which you are personally liable, but 25 lakhs out of that you have used for discharge of lawful liabilities of the firm. For that, we cannot make you personally liable. But for the balance 35, you are definitely personally liable because Prime Finance had no knowledge of the restriction in the partnership deed. Alright, reading further. Meanwhile, Bharat, second partner, secretly started a competing consultancy business and earned profit of 30 lakhs by diverting clients to the firm. Secret profit. Competing businesses. Okay. Later, Chetan, third partner, retired from the firm, but no public notice of retirement was given. Excellent. His name continued in the firm's document. After retirement, Aman entered into a contract with Vertex Builder Limited on behalf of the firm. Vertex was unaware of Chetan's retirement. Everything which is supposed to be done is exactly done in the opposite way. The firm subsequently became insolvent. Answer the following as per the Partnership Act 1932. 1. Whether the firm and all partners are liable to Prime Finance Limited for the loan taken by Aman. Yes, firm is liable. Mutual agency, one for all for one. But firm will recover out of total 60 lakhs, 35 lakh rupees from Aman because 25 lakhs, check it out, were used for lawful discharge of firm's liability. So 35 lakhs, Aman will become personally liable. Whether Prime Finance can recover full amount? Yes. Yes. They will recover full amount from the firm, but firm in turn will recover the balance 35 lakhs from Aman. Alright. Second, examine Bharat's liability for carrying on. Guys, if you do any competing businesses which was expressly mentioned in the partnership deed as not allowed, then there are only two ways. Either you do that with approval of all the partners or whatever profit you make shall be accounted as the profit of the firm. So in this case, Bharat will have to account that profit as the profit of the firm. 30 lakhs, full profit. Check it out. Done. Next, whether Chetan is liable? Unfortunately, the answer is yes because there was no public notice given. If there is no public notice, the partner shall continue as a partner by estoppel. Section 28. Section number 28. Don't forget. Okay, good question. I like this. Done. Going further, question 6B, option 1. Okay, this is again to be taken up by Nihal sir. Option is again contract to be taken over by Nihal sir. Oh, last question for my discussion. and that is again LLP. Okay, and of course IRF. Question 6 is what we are doing, and that's the B part. Come on, let's do it. Who is the designated partner? Lovely. What are the responsibilities? Guys, as per the LLP Act 2008, it is compulsory for every LLP to have at least 2 designated partners. Both shall be individual, at least one shall be a resident of India, meaning should have stayed in India for at least 120 days in the preceding financial year. Every designated partner shall obtain a DPIN, designated partners identification number, and his responsibility shall be to comply with all the legal compliances of the LLP. Short note question. Simple. Very simple. Don't forget to write all the points over here. And of course, last question. Explain the role of the Ministry of Finance in enforcement of business law. Again, a pure theory question. Lovely. For 3 marks. Guys, this is your CA Foundation AI generated paper of business law, where we have very reasonably and quite easily taken over the 5 chapters excluding contract and the SOGA. I believe that whatever discussions we have done, they were sufficient. It was not that difficult, but yeah, this could be a kind of a paper which AI can get into, right? So now I would want Nihal sir to step in, and he will take over the balance part of your contract and SOGA. Thank you guys.
Hi guys, I assume I'm audible to all of you. Hi guys, I assume I'm audible to. Hello, hello. Hi guys, I assume I'm audible to all of you. Perfect.
Yeah.
Hi guys, I assume I'm audible to. Okay. So guys, Rahul sir just
Hello.
finished discussing the entire paper with you,
Hi
except
guys, I assume I'm
the
audible to all
contract
of
and the
you.
SOGA part. Let's continue with that part. Well, before I start with that,
Yeah.
hi guys,
rough
rough
analysis
analysis
of
of the
the
entire AI generated paper.
Okay.
Well, one thing that
so
AI
guys,
has done well is Rahul sir
it has
just
matched
hello.
the easy and the
discussing
difficult part,
entire paper with
quite
you,
well.
except
Hi guys, I assume I'm
the
audible to all
contract
of
and the
you.
SOGA part. Let's
a bit more
continue with
difficult
that
as
part.
compared to the ICI
Well,
paper.
before I start with that,
Yeah,
a normalized
hi guys,
rough
I assume
analysis
I'm
of the
audible to-
entire
Having said that,
AI
if you
generated.
realize that there are 3 or 4 questions in the paper which are extremely difficult, the balance paper is manageable. So this is what the institute plays around with. What it does is, it puts some difficult parts so that you get stressed, and it puts it in between or in the beginning, and that's where it plays with your psychology. A smart student would choose smart questions and ensure that the difficult part is kept towards the last, so that even if you go wrong or if you lose marks, you don't end up losing too much. It doesn't affect your overall paper. Well, there are definitely some flaws with the paper as well. I mean, it's an AI generated paper. So beyond a point, we did not bother messing around with the paper. We continued with what was generated with the prompt given to Claude. Having said that, let's begin with the paper. Okay, I've already ticked questions which Rahul sir has solved, so that we are very clear what we are exactly approaching. Let's begin, guys. So, we've got question number 1A. Okay, Raghav, a wealthy businessman, promised his niece, Sia, that if she secured more than 80% marks in CA Foundation examination, he would gift her a luxury car worth 18 lakhs. So we've got a gift, luxury car, 18 lakhs. I just don't care. We're talking about gift. The promise was made in writing, signed by Raghav, but was not registered. Sia secured 84%. Well, the promise was to get 80 and she secured 84. However, before transferring the car, Raghav suffered business loss and refused to honor the promise. Further, Raghav orally promised his servant, Hari, that he would pay him 5 lakh if Hari continued serving the family without salary for 1 year. Hari continued to serve for 1 year, but Raghav refused to pay. Examine the validity and enforceability of both promises under the Indian Contract Act 1872. Well, this question deals with 2 concepts. The first concept is about a gift, and the second one is about a promise for past voluntary service, maybe whether it is voluntary or no, let's check. Okay. Now, Raghav promised Sia that if Sia got 84% in her CA foundation, he would gift her a luxury car. So let's understand, 80% plus luxury car, well, does not intend to create legal relations. But having said that, he's given it in writing. Well, let's go to the concept of no consideration, no contract. The doctrine which says nudum pactum, I mean agreement without consideration, is void. Well, agreements without consideration are void, but there are exceptions to this rule. And one of the exceptions is a completed gift. Well, check. Is this gift completed? No. So this doesn't fall in that exception. Okay, there's one more exception. An agreement in writing and registered between parties standing in near relation with each other out of the natural love and affection. Well, is the agreement in writing? Yes. Are the parties in near relation? Yes. Is there natural love and affection? Well, the question has nothing to indicate that there is absence of natural love and affection. So I will assume that natural love and affection exists. However, this does not have registration. Agreement in writing and registered between parties standing in near relation with each other out of the natural love and affection. 4 criterias to be fulfilled, and all 4, not one of the 4. Well, because it's not registered, it doesn't fall in this exception, and the other exceptions anyways don't apply. You don't need to discuss them in the exam. So I would basically say it is neither a completed gift nor agreement in writing and registered between parties standing in a relation with each other out of the natural love and affection, which means it falls in none of the exceptions and hence it is not enforceable. Cool. Let's look at the second part. Further, Raghav orally promised his old servant Hari that he would pay him 5 lakhs if Hari continued serving the family without taking salary for 1 year. So Hari would not take salary for 1 year, and at the end of 1 year, Raghav would pay him, Raghav would pay him 5 lakhs. Well, technically, that's a valid contract. That's a valid contract. There is nothing in it. Just because it is verbal, that does not mean it's not enforceable. Because when the question tells you it's verbal, you believe that even these things are enforceable, which means it's a valid contract. So remember, Sia cannot sue Raghav, but Hari can sue Raghav. These 2 parts. Well, if I was a paper setter, for me, the first part of the answer would be 4 marks. The second part would be 3 marks. Drafting it well. Your format, if you remember, your format should be, first, the given question deals with the so-and-so concept. Second, the provision. You will here quote agreement without consideration is void. However, there are certain exceptions. Write those 2 exceptions. That's it. Then agreements can be expressed, or contracts can be expressed or implied. This is an express contract. You'll not write it here. You've currently written the provision. Then you go forward. Then you say facts of the case, give a précis of this, and then say, as this promise is not registered, it is not a completed gift, it does not fall in the exception, and hence, conclusion, Sia cannot sue Raghav. And the second one, enforceable. I hope I have conveyed it. That's how you would be presenting your answer. Simple English, basic legal terminology, and take away your marks. It's not that difficult. Be very smart. If I was the one attempting this paper, I would be very happy. My first question goes right. In fact, the B part was very easy. Rahul sir discussed it with you guys. Indoor management is also easy. Okay, let's look at the C part. Well, honestly, though AI says it's a 6-marker question, I'll take it, but otherwise it is not. But I mean, I wouldn't ask this for more than 4 marks if I was to set the paper. But well, let's take it as it comes. Now, A agreed to sell 500 bags of premium wheat stored in warehouse number 8 to B for 12 lakhs. Before delivery, due to accidental flooding, 300 bags were destroyed without fault of either party. Without fault of either party. You are required to discuss the status of the contract and the rights of buyer and seller. Also state the effect of flooding on the price and delivery. Okay. Well, you're talking about Sale of Goods Act here. Or is it contract? Well, the question is silent. Normally, your question should tell you which act it deals with. But let me take, is there an indication? Yes, you're talking about, look here, rights of buyer and seller. So I would assume it's a question on SOGA and not a question on contract. Well, somebody in this case could answer it as per contract also. Supervening impossibility would apply. But please observe, that's the AI problem. They should have mentioned the act. Having said that, I'll answer it as per SOGA. Let's understand. Section 7 and 8 of Sale of Goods Act deal with destruction of goods. Well, Section 7 says if goods are destroyed before the contract of sale, without the fault and knowledge of buyer or seller. Section 8 says if goods are destroyed after agreement to sell, but before sale, without the knowledge or fault of buyer and seller, or without the fault of buyer and seller. In that case, what happens? In that case, if the contract was for sale of ascertained goods, if the contract, I'm talking about the applicable provision, Section 8, if the contract was for sale of ascertained goods, then the contract is void. Well, why am I saying contract is void? Because it's a supervening impossibility. It has become impossible later. Do not use the word supervening impossibility if you are answering it as per SOGA. Let's not confuse the two acts. Okay. Second, if it was for sale of uncertain goods, well, I can buy it from the market and sell it. Which means this agreement, I repeat, this agreement, which has already become a contract, is void if the goods were ascertained and valid if the goods were unascertained. So I just need to check whether the goods were ascertained or no. 500 bags, well, 500 bags is just the quantity. Stored in warehouse number 8. Stored in warehouse number 8. And due to accidental flooding, 300 bags were destroyed. Well, if 300 bags were destroyed without the fault, it means, were the goods ascertained? Yes. You know which goods were destroyed. So if the goods were ascertained, the contract becomes void. I repeat, the contract becomes void. And if the contract becomes void, what are the rights of buyer and seller? Well, the buyer is not buyer is not liable to pay for it, and seller is not liable to deliver the goods. But now the question is, what about the 200 bags which are not damaged? Now if you realize, there is a single promise, there is a single consideration of 12 lakhs. You can't separate it. It's a non-severable contract. And if it's a non-severable contract, the entire contract is void. Suppose it was a severable contract. Remember, you can sever the bags, you can't sever the contract here. So here the entire contract is void. But if suppose you had a situation where they had given you a question which said wheat and rice, and you could sever one, not the other, then in that case, you would have said the one which is destroyed is void, but the other is still valid because there was separate consideration for both. But again, let's not divulge into that. Answer this question. It's void. The buyer is not bound to pay. The seller is not bound to deliver. That's it. I repeat, that's it. I hope my kids have understood. Awesome. Done. Okay. Question number 2A. Distinguish between coercion and undue influence. It's a question for 3 marks. So reasonably, I'm expected to write about 4 to 5 good points along with basis of difference. I'm repeating, you are expected to write basis of difference if you want to score full 3 on 3. So first is applicable section, section 15, section 16. You can also, it's coercion and undue influence, perfect. Section 15, section 16. You can also give the definition. Coercion is committing or threatening to commit any act forbidden by the Indian Penal Code, or unlawful detaining or threatening to detain the property of any person to his prejudice in order to induce him to enter into a contract. Undue influence, come on. What's undue influence? When the relations between parties are such that one of them is in a position to dominate the will of the other and uses the position to obtain unfair advantage, he is said to have exercised undue influence. Second difference, coercion is an offense, undue influence is not an offense. Third, contract is voidable at the option of the aggrieved party in case of coercion. In case of undue influence, not only is the contract voidable, the court may set aside the contract, the court may rescind the contract completely or partially. Section 19A. Section 19A. Another one, the person exercising undue influence cannot outsource it. So basically, undue influence is applied by party to the contract, whereas coercion is applied either by party to the contract, or you may hire a goon to apply coercion, which means it may be applied by party to contract or may be applied by someone else. Well, that's the difference between coercion and undue influence. Beautiful 4 points which I have just mentioned right away. Fair enough. 3 marks, basis of difference, 4 difference with section number. Nothing more is necessary. Nothing more is necessary. If you still want to add a 5th point, you can add it. Coercion involves a physical force or a threat, whereas undue influence is a mental or a moral pressure. A mental or a moral pressure. That's your 5th difference. Take away your 3 marks, nothing to lose. I repeat, nothing to lose. Cool. Let's continue, guys. Okay. Now, B part was done by Rahul sir. It's a question on whatever. ठीक है. Okay. P purchased a water purifier. I'm looking at the C part, C1. Okay, it's a question for 3 marks, and the second part will be for 4 marks. P purchased a water purifier from Q, relying upon Q's statement that it removes all harmful bacteria. Removes all harmful bacteria from water. The purifier failed to perform as promised, and P suffered illness due to contaminated water. Discuss remedies available to P. Remedies available to P. So exactly which unit of your SOGA does the question deal with? It deals with unit 2. Okay, sir, unit 2, fair enough, but come on, is it a condition or a warranty? Let's understand. Are you talking about claiming damages? Yes. But are you also talking about cancelling the contract? Yes. Well, remember, water purifier is not disclosure of dangerous nature of goods. There are 4 implied warranties. Free from encumbrance, not applicable. Disclosure of dangerous nature of goods, well, water purifier wasn't dangerous nature of goods, not applicable. Warranty implied by customer, usage of trade, no. Well, what it did not meet is sale as to condition as to sale by description, as well as sale by mercantile quality. What's the mercantile quality? The quality which is expected from the goods, the basic quality which is expected. It's not the buyer's desired, but the basic quality that's expected. So you could answer as per both the parts here. In case of sale by description, there is an implied condition that the goods shall be of a mercantile quality. As the goods are not of mercantile quality, you have a right to rescind the contract and claim damages. So you are basically referring here to section 16. I repeat, you are basically referring to section 16. Subsections are not required. Somebody still wanting to quote it can quote 16.1. Cool. Easy part. There wasn't anything more in it. Discuss the provisions relating to determination of price under the Sale of Goods Act. Well, I should be happy with this question because it's a direct question. I either know it or I don't know it. I either choose this question or I don't choose this question. Well, I would have chosen this question because if you observe up, coercion under influence was easy. Oh wait, I missed out the second part. I'll take that up. I'm sorry, I missed it. I'll take that second part. B part was on partnership. That was also easy. Minor, easy. Fair enough. Now. Discuss provisions relating to determination of price under Sale of Goods Act. Well, determination of price under Sale of Goods Act is section 9 and section 10. Section 9 says price in a contract of sale shall be determined by proceeding sequentially in the following manner. First, price shall be determined by agreement between parties, or second, the manner provided in the agreement. Third, course of dealings. Fourth one isn't stated but is applied. If nothing else works, a reasonable price shall be paid. This isn't mentioned in section 9, but we apply in all practical cases. Then we go ahead. Section 10 says, price in a contract may also be determined by a third party. However, if such a third party fails to determine the price, the contract becomes void. But if the buyer has already appropriated the goods, consumed the goods, used the goods, sold the goods, done something with the goods which has changed the ownership or the identity of the goods, that's what I would mean by the word appropriation, then a reasonable price will have to be paid. Well, section 9 and section 10 both put together would give me my 4 marks, 2 marks for each. Cash marks, nothing to lose here. Sorry, I missed that part, the second part in A. A agreed to indemnify B against legal proceedings initiated by C. Well, A agreed to indemnify, so we are reasonably talking about a contract of indemnity. It could be a guarantee, but I'm as of now talking about indemnity. B incurred legal expenses and other costs and demanded reimbursement from A. Fair enough, it's indemnity. You are required to state whether B is liable to indemnify A for the above expenses and costs. Well, yes. This question basically has given you the answer only. मतलब AI ने जब ये पेपर बनाया तो सोचा एक काम करते हैं, कुछ easy डाल देते हैं बच्चे के लिए, wherein let him just identify the section number and write the provision. So basically यहाँ पर 3 mark आंसर बताने का नहीं है. You don't get 3 marks here for giving the answer. You get 3 marks here for identifying the section. Chalo, even if you don't remember the number, I'm fine. You should remember the provision. It's section 125. 125 says, amongst other things, the amounts that the indemnified can claim from indemnifier would include: 1. Legal expenses incurred in filing or defending a suit. Amount paid under a compromise or settlement with the consent of indemnifier. And any amount or any compensation awarded by the court. In the given question, it was clearly agreed that he would indemnify. But what's more important is, you also have to state the time when the liability of A arises. This is very important. Section 124 says that the liability of indemnifier, listen to me carefully now, the liability of indemnifier arises when the amount of liability becomes absolute and certain. Actual discharge or actual payment by indemnified is not required before claiming the money from indemnifier. Actual discharge of liability or actual payment by indemnified is not required before claiming it from indemnifier. So the liability of indemnifier arises, I'm talking about the timing now, arises when the amount of liability becomes absolute and certain. Becomes absolute and certain. That becomes your second part to it. I'm sorry I missed it earlier. I have just finished this. So if I just go on ticking so that I know I don't miss anything. A part was done by me. B was done by Rahul sir. C I finished. 2A is done. Well, 2B was done by Rahul sir. I finished 2C. 1 and 2 both. Wow. This is a very interesting question. It clearly uses Sale of Goods Act. Wow, this is one of the difficult questions. But if you look at the beauty, this is a question for, I didn't copy the marks here. It's a question for 6 marks. I repeat, it's a question for 6 marks. Okay. So if you look at the B part and the C part, they are extremely easy. C part is a direct question. B part, you guys cannot go wrong. The second part is constructive notice. I mean, these are cash marks. So technically, even if I wasn't sure about the A part, it's a difficult question. I've read it. So you guys should know one thing, that you're confident about 14 out of 20. This should be a question you should be attempting. Leave space about 2.5 sides for this and move. Attempt the balance part, maybe come to it later. But let me read the question first. Mohan owns a luxury car which he often allows his friend Raj to use for social events. Mohan allows Raj to use his car for social events. In January 25, Mohan flew abroad for 6 months, leaving the car and its documents in Raj's possession, but without any authority to sell it. Without any authority to sell it. While Mohan was away, Raj, pretending to be the owner, sold the car to Meera, a second-hand car dealer who purchased it in good faith and for value. Meera then resold the car to Neil, an unsuspecting buyer, which means again bona fide buyer, good faith, who verified the vehicle's registration papers and found them in order. A month later, Mohan returned and discovered that his car was missing. Upon investigation, he learned of the two sales and demanded the car back from Neil. Cool. Meanwhile, Meera, on realizing Raj's misrepresentation, sued Raj for fraud and also sought to recover her money from Mohan, claiming that Raj was his agent. You are required to analyze the validity of each transaction under the Sale of Goods Act 1930 and determine whether Neil or Mohan has a better title to the car, giving detailed reasons. Well, it's a 6-marker question. I honestly put in 2 minutes reading it. I've got about 8 minutes to write the answer, but I'm not going to make a mistake of directly jumping onto the answer. I'm going to make a flow to understand what has happened exactly. I've understood the question, but I still don't want to take a chance with the names. So what happens is, Mohan gives the car to his friend Raj for social events. So that's a contract of bailment. Without the authority to sell. I know this. But Raj sold it to Meera. Raj sold it to Meera, who is a second-hand dealer. while Mohan was away. This was Mohan. Okay. ठीक है. Next is Mira then resold it to Neil. Mira then resold it to Neil. Okay. Mohan returned and discovered that the car was missing. Upon investigation, he learned the two sales and demanded the car back from Neil. Meanwhile, Mira, on realizing Raj's misrepresentation, obviously, when Raj sold it to Mira, Raj has misrepresented it is what Mira says. Sued Raj for fraud. Well, is it Raj's fraud? The answer is yes. Sued Raj for fraud. And wants to recover from Mohan, as Mira says that Raj is his agent. Raj is the agent of Mohan, and therefore the principal is also liable. Again, I am not saying it. Mira says it. Now, you are required to analyze the validity of each transaction under the Sale of Goods Act. Determine whether Neil or Mohan. Let's understand who is Neil. This is Mohan. This is Neil. Has a better title to the car, giving detailed reasons. Brilliant question on nemo dat quod non habet. No one can give a better title than what he himself has. However, this rule has got some exceptions. So let's understand. I now have flow in my mind. Let's say I took 2 minutes to read the question, 2 minutes to make the flow. Now I've got exactly 6 minutes to write the answer. So listen to me carefully. In my 6 minutes, how am I going to fruitfully utilize my 6 minutes so that I don't overshoot the time? Well, first I'm going to say the given question deals with the concept of transfer of title by non-owner. Next, applicable provisions. Well, nemo dat quod non habet says no one can give a better title than what he himself has. So a person who is not the owner cannot transfer ownership. However, there are certain exceptions to the rule. Well, you don't have to state all the 10 exceptions that exist. I mean, there are 8 in the study material. The 8th one has 3 parts to it, so that effectively 10. You don't have to write all of them. You write only the relevant ones here that might end up confusing you. Well, sale by a mercantile agent is one part. Second, transfer of title by estoppel. So I'm going to discuss both. One of the exception is sale by a mercantile agent. When a mercantile agent within his authority, beyond his authority, transfers a title, the transferee gets a good title if he buys in good faith. I'm not going to analyze anything here. I'm just writing the provision. Second part. Similarly, when the owner represents that the seller has a right to sell. I repeat, when the owner represents that the seller has a right to sell, he will be stopped from denying it subsequently. Facts of the case, I'll summarize the question. And now I say, in this question, Raj is not an agent of Mohan. Why? The question clearly says Raj did not give him the authority. Second, Raj pretended to be the agent. So Mohan neither gave him the authority nor indicated it, which means Raj is not the agent, and therefore Raj cannot transfer ownership under the mercantile agent category. Next point. Also, the question nowhere indicates that Mohan represented it to anybody that Raj has a right to sell the goods. So the owner did not represent, and hence the rule of estoppel does not apply. Therefore, Raj does not get a valid title. Now, Raj does not have a title, so Mira does not get a title. Why? Because Raj to Mira does not fall in any of the exceptions. Therefore, Mira does not get a title. And if Mira does not get a title, Neil does not get a title. The good faith part does not matter unless you fall in any of those exceptions. Since none of the exceptions to nemo dat quod non habet apply, Neil does not get a valid title. Second, can Mira recover? Second part of the question was, Mira wants to recover her loss from Raj and Mohan. Raj because Raj committed fraud, and Mohan because Raj was Mohan's agent. Mira's contention. Now, Mira can recover from Raj, but not from Mohan because simple. Raj was not Mohan's agent, so Mohan was not the principal, hence not liable. But Raj committed a fraud, so Raj is liable to Mira. Analysis and conclusion. All my explanation came in my analysis. I nowhere used it in my provision. I hope you guys have got it. Let's move. B part was done by Rahul sir. C part was also done by Rahul sir. Brilliant. 4. Array, super. Negotiable instruments, easy question. Okay. B. A agreed to indemnify B against consequence of legal proceedings initiated by C. Guys, it's a repeat question. Same paper, different names. 2 questions chipcofied without using brains. Not my fault, we've done this. A delivered gold ornaments to B for safe custody. B negligently kept them unlocked and the ornaments were stolen. B negligently kept them unlocked and the ornaments were stolen. Discuss liability of B. Wow. Who says this part is difficult? Well, I would say this part is not difficult. But this part had IRF, which most students in the exam leave for option. I know you guys have not. You guys are smart kids. But most students leave it for option. So institute said, ले इसके साथ कुछ easy लेता जा. अब you will lose marks somewhere. Well, let me put it. Guys, it is the duty of the bailee to take care of goods as a man of ordinary prudence would take with respect to his own goods. Section 151. If he takes such care, 152 protects him from any loss. But in this case, the question clearly says the bailee has not taken care of goods. Bolo yes sir, no sir. Sure. Done. And therefore, B is liable to indemnify A for his loss because bailee has not fulfilled the duty. Somebody might say, sir, but it uses the word custody and mere custody is not bailment. And I know mere custody is not bailment, but the question nowhere indicates it is mere custody. It can be custody with the possession. Na? When would I say it is mere custody? When you would have said A delivered gold ornaments to B for safe custody and kept the key himself. And kept the key of the locker himself. Then I would say it is mere custody and therefore it is not bailment and therefore B is not liable. But in this question, the question never indicated that. So you need to be careful. I could have slightly modified the question. So then why didn't you modify? Because I didn't make it. It was made by Claude. Clear? Cool. Hey guys, 151, 152. I hope everyone's understood. Cool enough. 5th question तो मेरे को देखना ही नहीं है. It was entirely done by Rahul sir. Yes, it had everything about, come on, partnership, negotiable and company. Okay, we talk about question number 6. A part was done by Rahul sir. C part was also done by Rahul sir. Or lovely. So I need to take care of only B part, which has got 2 options. I'll cover both with you guys. Chalo. So guys, first part was for 4 marks. Second part is for 3. And here also it is 4 and 3. Okay, come. A appointed B as his agent to purchase goods on his behalf. B purchased goods in his own name without disclosing agency. Discuss the rights and liabilities of parties. Well, it's a interesting and a slightly difficult question. Because people generally mug up this concept and exam mein aayega to dekh lega. Well, they asked you a direct question on it. Why it's a direct question? They have just named A and B. Otherwise, they've just asked you to state the provision. I'm going to state it. Listen to me carefully. Anybody who writes this smartly gets 4 on 4. Not a single mark lost if you attempt it smartly. Listen to me carefully. Guys, they appointed B as the agent to purchase goods on his behalf. He did not disclose the agency. Discuss the rights and liabilities of parties. So basically you're talking about the third party's rights here. As a third party, I have an option either to rescind the contract or to continue. If I rescind the contract, I can claim damages for fraud. But if I agree to continue, then my rights against the principal, that is my rights against A, will be same as my rights against B. So third party's rights against B, whatever third party had, same rights, I repeat, same rights the third party will have against the principal, that is A. Same way, the rights which B had against third party, same rights A would have against third party. So A's rights against third party would be same as principal's right against third party would be same as
the agent's right against third party would be subject to the agent's right against third party. Is that clear? So, you're talking about rights of third party and rights of principal against the agent. Right of third party. Acha, by the way, one more part. The third party can recover from both if he chooses to continue. The third party can recover from both the principal as well as the agent. The principal as well as the agent. So guys, he can rescind 1 mark, recover from principal or agent 1 mark. Principal's right, third party's right against principal will be same as third party's right against agent 1 mark. And principal's right against third party will be same as agent's right against third party 1 mark. Present this beautifully in decent language and take away your 4 marks. Can silence amount to acceptance? Discuss with exceptions. Contract Act. Yes, perfect. General contracts. Can silence amount to acceptance? Well, no. Mere silence cannot amount to acceptance. Are there exceptions? Well, there are 2 exceptions. 1. Listen to me carefully. People could normally would think of only 1 exception. The second exception is not literally an exception, but your ICI module puts it as an exception, so we're going to discuss it here. The first exception is, guys, a general offer. Fulfillment of conditions implies acceptance. Carlyle versus Carbolic Smokeball Company Limited. Carlyle versus Carbolic Smokeball Company Limited. In a general offer, if you fulfill the conditions, you need not communicate your acceptance. Acceptance is implied by fulfillment of conditions. And second, what if at the time of offer it was indicated that failure to do something would imply acceptance, and the offer he had agreed to it and then taken the goods? Sale on return or approval basis. Here actually silence doesn't amount to acceptance. You had agreed in the past and then you had taken the goods. Now you are bound by it. For example, if A gives goods to B and says sale on return or approval basis, you have 15 days to respond. Otherwise, I will presume you have accepted, and now B takes the goods knowing this. Well, if you were B and you did not agree to it, you would not take the goods. But did you know it? Yes. Did you still take the goods? Yes. Which means you have now accepted it by your conduct, if you don't reject within 15 days. So these are the 2 situations where silence would also amount to acceptance. 2 mistakes students could do. 1, they would not write the entire scenario, I mean both the situations. Another mistake they could do is, they would write about offer. They would write about offer. Well, offer का आंसर नहीं लिखना है. Offer must be express or implied. Offer cannot be by silence. That's nonsense. That's not what you need to write here. Here your answer is clearly talking about acceptance. Speak only about acceptance. So this is a question where students might feel they know the answer, but actually they don't when they start writing it. So be careful. Okay, but the good part is even if you don't know it, you still have the second part because there is an option there. Your paper also has this option. This was clearly indicated in the prompt to Claude, so it gave us the options. Now let's look at it, guys. Everybody, please. Yep. Define contract of guarantee. Distinguish between surety, principal, letter and creditor. Very simple hai. Contract of guarantee, section 126. A contract of guarantee is a contract to perform a promise or discharge a liability of a third person. Contract to perform a promise or discharge a liability of a third person in case of his default. The person who gives the promise is a surety. The person to whom the promise is given is the creditor, and the person on whose behalf or who has a main liability or the principal liability is the principal debtor. The principal debtor has a primary liability, surety has a secondary liability, and creditor has a right. Cool enough. State circumstances under which quasi-contractual obligations arise. Come on guys, quickly. Beautiful question. Honestly speaking, this question is for 3 marks, but honestly this should have been for at least 6 marks because I have a lot to write. So I'm going to sum it up quickly so that I finish it within the required time of 5 minutes.
Quasi-contracts prevent unjust enrichment. Their relations resembling those which arise out of a contract. For those remembering in Hindi, do not write it in Hindi. ये रिश्ता ऐसा है जो contract जैसा है. These are relations resembling those which arise out of a contract. They prevent unjust enrichment. One cannot benefit at the expense of the other. There are 5 situations stated under the Indian Contract Act where quasi-contractual obligations arise. First, Section 68, supply of necessaries of life to a person incompetent to contract. Amount can be recovered from his estate. Do not write more, you don't have time. Second, when a person pays liability of another person, Section 69, when a person pays liability of another person to protect his own interest, he can recover the amount from such other person. Section 70, a beneficiary of a non-gratuitous act, non-gratuitous, not free, a beneficiary जिसने benefit लिया है किसका, एक ऐसे act का जो free नहीं है, is liable to compensate for the benefit received. Well, which means if you order a pizza and I eat it, I'm liable to pay for it. You are not. Section 71, finder of lost goods can recover expenses incurred on goods from the owner of goods. Remember guys, in all these cases, agreement was absent. Still the relations resembled those which arise out of a contract. It's called a quasi-contract or a semi-contract because an essential element of a contract, which is agreement, is absent. फिर भी रिश्ता ऐसा है जो contract जैसा है. And last but not the least, Section 72, when goods are delivered or money is paid. When goods are delivered or money is paid to a person by mistake or he has taken it from me by coercion, by force. Can I recover it? Yes. Agreement था? नहीं था. फिर भी क्या recover होगा? हाँ. Because quasi-contracts prevent unjust enrichment. Section 68, 69, 70, 71, 72. 5 sections and the introduction. Take away your 6 marks. Ideally, in this question, it was for 3. You remember I told you a question earlier where they had asked it for more marks, but you didn't have enough content to write. Here they've asked it for less marks, you have got enough content to write. Again, this unfair part will happen in the question, and therefore when the kids ask me, sir, what is the standard size of an answer? I say there is no standard size, but generally a 4-mark answer would take one side. Generally, these were the 2 exceptions in extreme cases. I hope my kids have understood. So guys, be really smart when you look at the paper. We had told Claude to make the most difficult possible paper, and this is what they had made. We could have made changes, but we didn't want to because we wanted to see how does the AI make the paper. Well, the papers that you guys have solved in your prelims have been difficult, more difficult than this. So, well, nothing more to say. All the best, take care, stay safe, focus on your language, be very cool-headed, and language is what is going to make the difference because everybody would know the answers. If you look at these questions, they resemble the questions which you will see in the ICI mock papers, model test papers, in the PDLC papers, or anything else, in the past papers, MTP, RTP, blah, blah, blah. Everything is similar in terms of questions. What's going to differentiate your answer is the language, the section numbers, and the way you present it. Hello? Brilliant. That's it, guys, from PDLC. Rahul sir, Nihal sir, end of the paper discussion. Bye-bye. Take care. Stay safe. See ya.